Procedural Fairness Section 3 of the Administrative Law module. And so we begin with a legislative analysis of Haja Section 3. Remember, this is Section 1 of this lecture, but in this Section 1, we'll be discussing or we'll be going through a legislative analysis of Haja Section 3. So let's begin. So, Haja Section 3, as it relates to procedural fairness, in Section 3.1, we deal with what is known as the jurisdictional facts. So, it goes without saying that Haja Section 3 gives effect to the right to procedurally fair administrative action. We get this from the title, right, of the section. However, before accessing the right to procedural fairness, an applicant must meet the requirements found in Section 3.1. These are known as the jurisdictional facts of Haja Section 3. So again, as we've stated, an applicant must meet the requirements found in Section 3.1. So Section 3.1 reads as follows: administrative action which materially and adversely affects the rights or legitimate expectations of any person must be procedurally fair, right? So again, Section 3.1 reads, administrative action which materially and adversely affects the rights or legitimate expectations of any person must be procedurally fair. Section 3.1 therefore requires the following jurisdictional facts to be satisfied before a person can be said to be entitled to a right to administrative action that is procedurally fair. So what are these jurisdictional requirements that must be satisfied? First, that the administrative action being challenged must affect a specific person, any person, taken to mean, as you will remember from the previous lecture on legality, this means warm bodies or private persons. That is to say, juristic or natural persons, and not the state for the purposes of Haja, right? Second, that the administrative action must materially and adversely affect, right? This means that the administrative action cannot be trivial or inconsequential in nature and the extent that it affects, right? So the effect must be material and adverse, right, on the applicant, right? It cannot be trivial and it cannot be inconsequential. And third, administrative action must materially and adversely affect what? Rights or legitimate expectations of the applicant. This means that a right or legitimate expectation must be the subject of the administrative action's material and adverse effect. It cannot merely affect an interest or concern. So the subject of the administrative action cannot be a mere interest or concern. Okay, now we move on to section 3.2a, which discusses the inherently flexible principle of procedural fairness. The idea is that procedural fairness is an inherently flexible principle that is not fixed, or in other words, simply taken to mean that what constitutes procedural fairness will be different as the circumstances prevail or on a case-by-case basis, right? So section 3.2a reads, a fair administrative procedure depends on the circumstances of each case. In other words, procedural fairness in any given case, excuse me, is context specific and will depend on the circumstances of each case. Procedural fairness, therefore, is an inherently flexible concept that may require 1 day's notice for a decision in response to urgent disasters or extended notice in regard to housing development or and even legal or written representation in complex legal matters. These are provided as examples to demonstrate or display that the principle or the concept of procedural fairness is not fixed and would depend on the circumstances of each case, requiring or having different things. Okay, section 3.2b, procedural fairness requirements. In other words, what does procedural fairness look like? So section 3.2b provides guidelines to administrators on how to give effect to the right to procedural fairness in section 3.1. And while it may seem to impose mandatory guardrails, what we must note is that section 3.2a, aforesaid, provides that procedural fairness is an inherently flexible concept, remember? And further subsections 3, 4, and 5 buttress this or support this notion, with the section specifically being subject to subsection 4. This will be explained in a moment, right? And so first, what is provided for in section 3 to B, Roman numeral 1 to 5, is that persons who will be affected by an administrative, by an or the administrative action must receive adequate notice of the intended action. Not simply that they must receive notice of the intended action, but that it must also be adequate, right? So one of the requirements of procedural fairness is providing the person who would be affected by the administrative action with adequate notice of the intended action. It is not simple that they must simply receive notice of the intended action, but it must also be adequate, right? Adequacy, being relative in terms, means that what constitutes adequate notice may depend on each case in question, with the form, written or verbal, and the time of notice being the main subject of scrutiny. Remember, in the previous slide, we talked about 1 day's notice in terms of an urgent disaster and perhaps extended notice as it pertains to housing issues. So the adequacy of the notice is very important, right? Second, right, that the person who will be affected by an or the administrative action must receive a reasonable opportunity to make representation, right, or to state their side. Ordinarily, the opportunity to make representations must be afforded before the decision is taken, right? It must be afforded before the decision is taken. It must be noted that the purpose of said representation is not that it will guarantee any outcome, but that it may influence an outcome, right? So the reasonable opportunity to make representations must be afforded before the decision, ordinarily must be afforded before the decision is taken. And the purpose of said representation is not that it will guarantee a particular outcome after representation is made for the applicant, but that it may influence the outcome or the decision of the administrator or administrative body. What constitutes a reasonable opportunity to make representations depends on the circumstances, as we've noted, that procedural fairness is a flexible, or what is more clearly put as an inherently flexible concept. And so what constitutes a reasonable opportunity to make representations depends on the circumstances of each case. So whether that is written or verbal representations, or whether the time allowed is lengthy or short, depends on the circumstances of each case. We're continuing with section 3, 2b, Roman numeral 1 to 4, procedural fairness requirements. And so we now look at the third Roman numeral, right? That persons who will be affected by an or the administrative action must be advised by the administrator in clear terms of the decision. So they must be advised of the decision taken by the administrator, and this would require a clear statement of administrative action that ought to set out what was decided, who the decision makers were, and on what legal or factual basis the decision was taken. Right? Very important. What is required of this requirement that the administrative action must be advised by the administrator in clear terms of the decision, or that the person being affected or will be affected by the administrative action must be advised by the administrator through providing a clear statement of administrative action. It ought to set out, again, what was decided, who the decision makers were, and on what legal and factual basis the decision was taken. It must be noted that the purpose of the aforesaid statement is that it would ideally allow the affected persons to decide on whether or not they wish to appeal or have the decision reviewed. So this clear statement of administrative action, right, must be such that from the applicant reading the clear statement or the statement of the administrative action, they can decide whether or not to have the decision appealed or have the decision reviewed. And so it must be clear, again, setting out what was decided, who the decision makers were, and on what legal and factual basis the decision was taken. Fourth, or Roman numeral 4, the persons who will be affected by and or the administrative action must be informed by the administrator of any internal or special statutory review procedures, or any internal appeal procedures available in respect of said administrative action. Now, the appeals process may be found in a particular statute. For example, perhaps maybe Transnet in its empowering provision or empowering act, perhaps let's call this act the Transnet Act, may provide for an internal review procedure, or if it does not, nonetheless, they may have an internal appeals procedure available in respect of that administrative action. It must be noted that the administrator need not inform affected persons that they can pursue judicial review in terms of Section 6 of PAJA, only that they have a right of review or appeal, and how to effect that right if said is available, right? So in other words, the administrator simply needs to state that they may appeal the decision in terms of the special review procedures or any internal appeals procedure, but they don't have to advise the applicants that they can pursue judicial review, right? Judicial review is not an internal appeals process. It's different. It's now taken to court. They do not have to inform, right, the applicant that they can pursue judicial review in terms of Section 6 of PAJA, only that they have a right of review or appeal and how to affect that right, right? So how to go about applying for an appeal in terms of the review or internal appeals procedures that are available, right? Fifth, that the person who will be affected by an administrative action must be informed by the administrator that they are entitled to ask for reasons for the decision in terms of Section 5, right? This is different, as here it states what's in the third part, Roman numeral 3 talks about what was decided, who the decision makers were, and on what legal or factual basis the decision was taken. Here, it's more, it's different in that the applicant is entitled to ask for reasons for the decision in terms of Section 5. It must be noted that the burden placed upon the administrators herein is not that they must provide reasons for the administrative action, but they must inform the affected person of the right to request said reasons in terms of Section 5. Now, it's important to note that that the administrator must inform, all right, the applicant that they are entitled to ask for reasons for the decision in terms of Section 5, right? It's not that they must provide reasons for the administrative action, but they must inform affected persons of the right to request said reasons in terms of Section 5. As you see in the clear administrative statement, they don't provide reasons, simply what the decision was. However, perhaps maybe if an applicant wants to consider whether they want to appeal, then in making that job easier, they may want then to request reasons. And so the administrator must inform them of that entitlement to ask for reason in the same manner that it informs them of the right to appeal, right? Or review the decision internally. Okay, section 3.3a now to section 3.35, what is known as the discretionary requirements of procedural fairness. Start at section 3.3 now, which reads that in order to give effect to the right to procedurally fair administrative action, an administrator may, in his or her or its discretion, right? That's why it's known as the discretionary requirements, right? May also give a person referred to in subsection 1, the affected person, an opportunity to A, obtain assistance, and in serious or complex cases, legal representation, B, be present and dispute information and arguments, an opportunity to be present and dispute information and arguments, and C, appear in person, right? In other words, as a flexible concept in any given case, procedural fairness recognizes the potential need and therefore provides for affected persons to obtain assistance, legal representation in serious or complex matters, or to present and dispute information and arguments, and to appear in person rather than only through written representation. So where the case is complex and it's within the discretion of the administrator, they may allow for this, right? They may allow for an opportunity to obtain assistance in serious cases or complex cases, legal representation, B, present and dispute information and arguments, and C, appear in person, right? Section 4.A reads, if it is reasonable and justifiable in the circumstances, an administrator may depart from any of the requirements referred to in subsection 2, the one that we previously did here. Remember, subsection 2 on those five guardrails, what we call guardrails, right? So note that a discretion is provided for with the language of if it is reasonable or justifiable in the circumstances, an administrator may depart, right? That's where the discretion is provided for. However, the discretion is also limited to the circumstances being reasonable and justifiable, right? And so where it is reasonable and justifiable, an administrator may depart from subsection 2, which we just dealt with, where we talked about adequate notice, right to request reasons, etc., that we just previously have done. They may, they may, they may depart from any of the requirements referred to in subsection 2. And so remember, the court said that uh, the statute says that this discretion can only happen. In other words, the administrator may depart from the requirements of subsection 2 if it's reasonable and justifiable in the circumstances. Now, determining whether it is reasonable and justifiable or whether they can exercise this discretion. So in B, subsection 4, subsection 4, right? B, so this needs to read subsection, right? Subsection here, right? Subsection 3, subsection 4A, subsection 4B. In determining whether a departure as contemplated in paragraph A is reasonable and justifiable, an administrator must take into account all relevant factors, including the objects of the empowering provision. That means basically the empowering provision is the legislation that gives power to the administrator or administration to take such decisions, the nature and purpose of and the need to take the administrative action, the likely effect of the administrative action, the urgency of taking the administrative action, or the urgency of the matter, and 5, the need to promote an efficient administration and good governance. Aforesaid being the same, subsection 4 provides that an administrator then may depart from any requirements in subsection 2, provided that in doing so, it is reasonable and justifiable. So the exercise of the administrator's discretion here is subject to that discretion being reasonable and justifiable in the circumstances, right? It must be noted that the option provided for in the subsection 4 is that the discretion of the administrator, however, the requirement that the decision be reasonable and justifiable is not the same. That is to say, the decision must be objectively reasonable and justifiable, right? So even though they may exercise the discretion or decide for themselves, right, whether to depart, right, that's the discretion that they hold. The question of whether the circumstances allow for it in that they are reasonable and justifiable is objective. It's not whether, right, the administrator thinks to himself that circumstances are reasonable and justifiable, but whether objectively it is reasonable and justifiable in the circumstances to depart from the requirements of subsection 2, right? Of section 3. Remember, we are dealing with section 3. Okay. Determining said the administrator must take into account all the relevant factors, not just some, right? So that's why in determining whether a departure as contemplated in paragraph A is reasonable and justifiable, an administrator must take into account all relevant factors. This is basically a showing that determining the reasonable and justifiable circumstances for the departure is an objective inquiry, right? And it involves them considering the objects of the empowering provision, right? So the discretion is placed on the administrator. However, the inquiry upon whether that discretion may be exercised by the administrator is an objective inquiry. Okay. Now, lastly, subsection 3.5 reads, subsection 3.5 reads, where an administrator is empowered by an empowering provision to follow a procedure which is fair but different. Remember, in some cases, we said earlier that an empowering provision may provide for internal procedures, right? Earlier in subsection 2, analysis. In subsection 3.5 reads, where an administrator is empowered by an empowering provision to follow a procedure which is fair but different from the provisions of subsection 2, the administrator may act in accordance with that different procedure. May. So where you see may, that provides or indicates a discretion, right? A discretion. They may act in accordance with that different procedure. In other words, the subsection provides for an administrator to make use of another procedure that gives effect to procedural fairness, provided said procedure again is fair and found in an empowering provision, right? So, in order for them to depart from the requirements of subsection 2, the administrator may do so if another fair but different procedure that gives effect to fair procedural fairness, right? They can follow that procedure so long as that it is fair and found in an empowering provision. They can't, in other words, adopt a different procedure that is not fair or, most importantly, is not found in an empowering provision. So they may depart if their empowering provision provides for a procedure that is fair. Okay. We then now come to Paja Section 3, a review of the authorities. We are dealing here in particular with case law, and this is Section 2 of this lecture, right? However, note that we are still on Section 3 of the Paja, right? We're now looking at the cases. So, remember, we are now doing Section 3. Let me change the color. Okay. We are looking at case. Okay. How do I? Okay. Here. Okay. So we're looking at case law, and this case law, particularly these cases that we're going to be going through. Firstly, we start off with Section 301, which is the jurisdictional facts, right? And so we start with the case of State Information Technology versus Gijima, which we've done, and we look at the requirement, the jurisdictional fact of any person, right? So what do we mean by any person? You'll remember that we've done this case in the previous lecture on legality, where the court addresses the question whether a right to legal review is available to a state organ in terms of PAJA to set aside its own decisions. Answering this question, the court noted the wording of Section 33 and held that the state is not included in the word everyone, noting the same refers to warm bodies, i.e., private persons, highlighting this point by stating that it seems inconsonant that the state can both be the beneficiary of rights and the bearer of the corresponding obligation that is intended to give effect to said rights to procedurally fair administrative action, right? So when the jurisdictional requirement of any person, we note that this talks only about natural or juristic persons, what the court referred to as warm bodies, right? Not the state. Okay. Now, the court goes further to reason upon this point that from whom would an organ of state whose own decision is the subject of its concern expect this lawful, reasonable, and procedurally fair administrative action from itself? That simply cannot be. The court holds Section 33(2) affords a person whose rights have been adversely affected by administrative action a right to be given written reasons. Surely, it could never have been the object of the section that an organ of state should, like private persons, also enjoy a right to be furnished by itself written reasons for administrative actions taken by itself. It sounds really, the court's really displaying that it sounds inconsonant, i.e., it's dumb, all right? So when we look at the jurisdictional facts, right, the requirements that any person is entitled to the right to procedurally fair administrative action, what is required is that that person be a warm body, and we turn to this case of State Information Technology versus Kichima Holdings to make that argument, right? We're continuing now. We're still on Section 3.1, jurisdictional facts. We look at the jurisdictional fact of materially and adversely affect and that of rights, right? So, in the Joseph and others versus City of Johannesburg case, right? In the decision of this court, they considered the meaning of materially and adversely affect. The court held the requirement for materially and adversely affect, the requirement is not that there must be a breach of any right, but simply that the administrative action had a significant and not trivial effect. This requires that the administrative action also has a direct external legal effect, which serves to emphasize that the administrative action impacts directly and immediately on individuals, right? So how do we find whether an administrative act meets the requirement that it is materially and adversely affecting the applicant? The court states here that the administrative action, we must find that where it is found that the administrative action had a significant and not trivial effect, right? So what does this mean? This requires that the administrative action also has a direct legal effect, which serves to emphasize that the administrative action impacts directly and immediately on individuals, and that the impact is what? Significant and not trivial. And so when we find these things, that the administrative action impacts directly and immediately on individuals, and that impact or effect is significant and not trivial, right? Then it meets the requirement of materially and adversely affect. The court added that a finding of a materially and adversely affect on rights would necessarily imply that the decision had a direct legal effect on the applicants. On the question of rights, okay, the requirement of rights, same case, Joseph, the court held, rights in Section 3.1, that's of the PAJA, includes all private law rights, common law rights, constitutional rights, and any legal entitlements that are based on a corresponding public duty imposed on the organ of state, either by the Constitution or statute. And so where perhaps let's say the Municipal Services Act places the obligation on a municipality to provide refuse removal services, right? Then that forms a legal entitlement based on a corresponding public law duty. And so rights also includes that. It doesn't have to be constitutional rights. What we must note also, the court touched on the case of Van Rooyen and also engaged here the matter, of the negative aspects of rights, okay? The negative aspects of rights, the court also agreed with that point. That when we look at the word rights, there's positive aspects. For example, if you have the right to electricity, the positive aspect of that right is that you should get electricity, but also that the negative aspect of that right is that you should not be denied electricity, or a certain act should not take away from the positive aspect of you enjoying that right, such as shutting off your electricity, right? And so we must also note that rights includes these negative and positive aspects as found or supported for, in this case, supporting the Van Roon case, right, which dealt with sequestration, okay? So moving on to the jurisdictional facts of legitimate expectations now, we've dealt with any person, we've dealt with materially and adversely affect, we've dealt also with rights. We now look at the jurisdictional fact that in the event that it does not affect a right, it may affect legitimate expectations. And we now look at what legitimate expectations entail, right? The seminal case in South African law for legitimate expectations or establishing legitimate expectations is the case of Administrator Transvaal versus Traub, right? This seminal case, the court adopted the doctrine of legitimate expectations, tracing its origins and development in the English judgments, referred with approval to Lord Fraser's description of the principle, where he states, but even where a person claiming some benefit of or privilege has no legal right, to it, as a matter of private law, he may have a legitimate expectation of receiving the benefit of privilege, and if so, the courts will protect his expectation by judicial review as a matter of public law, right? So now they extend this to public law, right? So note that the court is saying that even though a person may have some claim of a benefit or privilege, but this person does not have a right. They just have a claim to a benefit. And as a matter of public law, he may have a legitimate expectation of receiving that benefit or privilege, right? The court says that it will protect the expectation, the legitimate expectation, by judicial review as a matter of public law, right? Legitimate legitimate or reasonable expectation may arise, either very important. So how do we note when a legitimate expectation exists, right? The court says a legitimate or reasonable expectation may arise either from an express promise given on behalf of a public authority or from the existence of a regular practice which the claimant can reasonably expect to continue. Very important, a legitimate expectation may arise either from an express promise given on behalf of the public authority or from the existence of a regular practice which the claimant can reasonably expect to continue. So when we're looking at our tests and we find these in our set of facts, we then know that a legitimate expectation exists, right? We then now look again at the National Director of Public Prosecutions versus Phillips. We look at still legitimate expectations. And here the court adds to what the case of Traub said, stating that the law does not protect every expectation, but only those which are legitimate, and the court provides the requirements for a legitimate expectation, stating the requirements for legitimacy of the expectation include the following. First, right, the expectation must be reasonable. The representation giving rise to the expectation, the representation giving rise to the expectation must be clear, unambiguous, and devoid of relevant qualification, induced by the decision maker, and one which was competent and lawful for the decision maker to make. So, before or it's not that only a legitimate expectation or a legitimate expectation arises from an express promise or from the existence of a regular practice. What we must look at further, so what the court is stating in National Director of Public Prosecution Phillips versus Phillips, what we must look at further is whether that expectation is reasonable. Look at whether the representation giving rise to the expectation was clear. So whether the representation, the promise, right, was clear, unambiguous, and devoid of relevant qualification, where it is unclear, ambiguous, and has relevant qualifications, right? It may not be, or it may not give rise to a legitimate expectation. It must be induced by the decision maker. So if the applicant, right, or the affected person, right, is the one that induces the promise, right? If they are the one who induce the promise, perhaps maybe nagging and harassing, then a legitimate expectation would not arise, right? So it must be induced by the decision maker. The decision maker's actions must give rise to the legitimate expectation, not the other way around, right? And also one which was competent and lawful for the decision maker to make. So if a decision maker, right, makes representations that give rise to the expectation, but that representation was not competent for him to make, or was not within his powers and was not lawful, then that representation would not give rise to a legitimate expectation. So, for example, if perhaps maybe an administrator in SARS, right, South African Revenue Services, says to a tax filer that, listen, you don't have to pay your taxes, that is not a representation that is competent for that administrator, nor is it a representation that is lawful for the decision maker to make. And so the tax filer then can't say that he had a legitimate expectation not to pay his taxes because of that representation. As we found, that representation would not be competent and not be lawful for the decision maker to make, and so it would not give rise to a legitimate expectation as claimed by the tax filer. I do hope that makes sense. I'm sorry, there's a bit of noise around me. There's a truck here. Okay, hopefully you can still hear me in the background. My God. Oh, yo. So we will try, hopefully that's they are building here. Hopefully that doesn't interfere with the audio and you guys can still hear me. Okay, now moving along, we are continuing on this. We are continuing on this topic of legitimate expectations, and we are looking at the case of SA Veterinarian Council and another versus Skimansky or Simansky. In the above case, the court adds to the NDPP v. Phillips case, stating subjective confusion by itself is no basis for a legitimate expectation. Still less can misinterpreting the words or actions of an authority give rise to a legitimate expectation, right? So it's adding to what the NDDP Phillips case stated as objectively what would give rise to a legitimate expectation. In this case, the court adds subjective confusion. So perhaps when an administrator made a representation, your confusion about whether or what that representation means, or whether it would entail the rise of a legitimate expectation or not, cannot come about based on your own confusion, right? So if an objective or an otherwise objective person or a reasonable person would look or listen to that representation, find it not to give rise to a legitimate expectation, your subjective confusion in the matter cannot be the basis of a legitimate expectation. Makes sense? You can't go now and say, oh, I thought that this was a promise, or this was a legitimate expectation, or this was the legitimate practice or regular practice. Therefore, I'm entitled, or I had a legitimate expectation. That would not fly, because if objectively speaking, a reasonable person or any other person would find that that does not look like or does not sound like a promise, then it's shy. Okay? So misinterpreting the words or actions of an authority cannot give rise to a legitimate expectation. Okay. Then we look at the case of Walele versus City of Cape Town and others. Again, note that we are still on the topic of legitimate expectations. The court held in deciding whether the applicant had established any legitimate expectation, referring to the test for determining the existence, right? The test for determining the existence of a legitimate expectation held. The inquiry is primarily factual, and the focus during this stage is on objective facts giving rise to the expectation. Again, non-subjective confusion, right? Or misinterpretation, objective facts, right? So we get to look at this now, this topic of legitimate expectation, we start to see that the court is developing more clearly this aspect of legitimate expectations, right? The court held that the aggrieved party's state of mind, similar to here, in other words, state of mind subjective, is irrelevant to the inquiry. Once the facts supporting an expectation are established, the inquiry moves to the second stage, which is whether in the circumstances of the case at hand, procedural fairness required a pre-decision hearing. This is now specific then to this case where Walele claimed he had a legitimate expectation for a pre-decision hearing. In some, the court added, the requirement is that the conduct underlying the expectation must reasonably lead to the belief that the aggrieved party would be given a hearing before the decision was taken. And so if you want to look at a claim of a legitimate expectation to a pre-decision hearing, we go to this case and we look at the inquiry. The court went on to clarify, referring to the common law tradition. Under the common law, the order principle originally applied where the decision affected the liberty, property, or existing rights of the claimant, and it was later extended to, right, decisions affecting legitimate expectations of claimants. The court now not only discusses the objective inquiry into whether there was a legitimate expectation that would require a pre-decision hearing, it also looks at what is protected, right? So the court then also deals with what is protected, and the court says that thus, even before the present constitutional order, courts in this country did not apply the order principle, procedural fairness, to administrative decisions which affected interests falling short of rights or legitimate expectations. Remember, we stated in our legislative analysis that what must be affected is a right or legitimate expectation. It cannot be interests or concerns, right? Presently, court continued, presently, Section 3 of PAJA makes it clear that the right to a hearing is available to persons whose rights or legitimate expectations are affected by administrative action. Thus, absent an affected right or legitimate expectation, the applicant cannot challenge the decision on the basis that he ought to have had been heard and was denied a pre-decision hearing. So where you do not have a right or a legitimate expectation that is affected or is going to be affected, the applicant cannot challenge the decision on the basis where a right or legitimate expectation does not exist. All right. So we now move on to section 3.2a, procedural fairness as an inherently flexible concept or principle, and we look at the English case of R versus Secretary of State, discussing this topic that procedural fairness is an inherently flexible concept or principle. And in this judgment, Lord Mustell states on what procedural fairness requires. He says, what does fairness require in the present case? My lords, I think it is unnecessary to refer by name or quote from any of the often cited authorities in which courts have explained what is essentially an intuitive judgment. They are far too well known. From them I derive. So Lord Mustell goes through case law history, and this is what he says. Procedural fairness entails as an inherently flexible concept, right? It says, when act of parliament confers an administrative power, an act of parliament confers an administrative power, there is a presumption that it will be exercised in a manner which is fair in all circumstances. The standards of fairness are not immutable. They may change with the passage of time, both in the general and in their application to decisions of a particular time. The principles of fairness are not to be applied by route identically in every situation. So not every situation calls for a similar address of procedural fairness. That means, in other words, where one decision may have required simply notice, it cannot be that every decision will require notice. Some decisions may require a hearing, etc., as the case may be, right? What fairness demands is dependent on the context of the decision, and this is to be taken into account in all aspects, right? So procedural fairness depends on the context of the decision. An essential feature of the context is the statute which creates the discretion as regards both its language and the shape of the legal and administrative system within which the decision is taken. Going on, fairness will very often require that a person who may be adversely affected by the decision will have an opportunity to make representations on his own behalf, either before the decision is taken with a view to producing a favorable result, or after it is taken with a view of procuring its modification, or both. Since the person affected usually cannot make worthwhile representations without knowing what factors may weigh against his interests, fairness will often require that he is informed of the gist of the case which he has to answer, right? Some cases it will require informing them of what is required of them to answer, right? You can see in his language of what procedural fairness entails, that Section 3 of PAJA, as well as further cases, case law, in South African case law, how very much similar it reflects this judgment, or how far it mirrors this judgment, both in our legislative text and in our case law, right? Now, we go to Section 3, 2b from Roman numeral 1 to 2, procedural fairness requirements, right? Remember subsection 2 of section 3 where we talked about the procedural fairness requirements. What would it require in a particular instance? And we look at here the adequate notice, one of the nature and purpose of the proposed administrative action. We look at the case, South African case now, of Bushila versus Permanent Secretary, Department of Welfare, Eastern Cape, right? So in the above court, Van Rensburg J held in regard to what constitutes adequate notice as follows. So this is what he held in regards to what constitutes adequate notice. Van Rensburg held, by proper notice, I mean that adequate steps should have been taken to ensure that the beneficiary under the grant receives such notice. Then again, it would not be sufficient to simply state generally that social grants would be reviewed annually and that reviewing would commence in 1996. The recipient of the grant would, in my view, be entitled to individual notice that his grant is to be reviewed. The notice should inform him of the salient factors which will fall to be considered and should further state when and where the opportunity to be heard may be exercised. So in this particular case, where the department wanted to review grants and where the department in this case put out commercials on the radio um, and on the radio and on billboards that grants would be reviewed. In this case, Bushila, right, did not receive such notice or contended that this was not adequate notice. The court dealing with this, Van Rensburg, said that adequate steps should be taken to ensure that the beneficiary under the grant receives such notice. So it's important that they receive the notice. The assumption shouldn't be made by the beneficiary that they would receive notice, but rather that they did receive notice, and that this notice should inform them of the salient factors which fall to be considered and should further state when and where the opportunity to be heard may be exercised, all right? Again, we then look at the case of Dupree's, right? Truth and Reconciliation Commission on the topic of adequate notice. Corbett CJ, referring to the judgment of King Jane Administrator, Cape Town and another, versus Ikapa Town Council ruled in regard to what constitutes adequate notice as follows held. It seems to me that in a case such as this, procedural fairness demands not only that a person implicated be given reasonable and timely notice. So what we get here is that the notice must be received or be given to the individual, right? And it must contain the salient features. Another aspect of adequate notice involves giving reasonable and timely notice of the hearing, right? Because the hearing was going to affect, was the decision or was the administrative decision that was going to affect Dupree's, as he was going to be implicated in wrongdoing, but also that he or she is at the same time informed of the substance of the allegations against him or her with sufficient detail to know what the case is all about. What is sufficient information would depend on the facts of each individual case. Right, so it involves giving reasonable and timely notice. It involves informing the person of the substance of the allegations against him or her. This involved criminal issues, so it should inform them of the substance of the allegations made against him or her with sufficient detail to know what the case is about, right? With sufficient details to know the gist of the case, right? What is sufficient information, as the court states here, Corbett CJ states here, would depend upon the facts of each individual case, right? Still continuing on this requirement of adequate notice in the case of Nkomo and others versus Administrator Natal and others, the court referring to submissions of counsel for the appellants, in which they cited a mere pretense of giving the person concerned a hearing would clearly not be a compliance with the rule. Nor, in my view, will it suffice if he is given such a right to make representations as in the circumstances does not constitute a fair and adequate opportunity of meeting the case against him. What would follow from the rule, the last mentioned proposition, is firstly, that the person concerned must be given reasonable time. So, in terms of adequate notice, note that a requirement of that is that they be given reasonable time in which to assemble the relevant information and to prepare, put forward his representations. Secondly, he must be in possession of such information as will render his right to make representations a real and not an illusionary one. So what happened in this case was that Nkomo and others decided to go on strike, right? And the administrator said that if you go on this illegal strike, then you should make representations as to why we should not dismiss you and giving notice of this intended decision to dismiss them for participating in the illegal strike. The administrator gave them a 48-hour notice that fell over the weekend, in which case these employees, firstly, not understanding English and not having time to respond to this proposed administrative action for their dismissal, the court is saying that they must be given reasonable time, finding that a 48-hour period that fell over the weekend in which to respond to this decision was not reasonable, and it was in effect an illusionary one. While it complied on paper, really it was illusionary because they would not reasonably have been able to respond to it, noting that these were general workers who did not understand English, who were of less than average education, right? So it should not be illusionary, right? And it would require reasonable time, right? We then look at a reasonable opportunity to make representation, still on subsection 2. Here, Roman numeral 2 writes, we look at a reasonable opportunity to make representation, looking at the case of save the val, right? We're just going to cite here, save the val, right? In addressing the issue of whether or not the audi partem rule applies to preliminary decisions, thereby warranting the need for representation, right? The court held it is settled law that a mere preliminary decision can have serious consequences in particular cases, inter alia, where it lays the necessary foundation for a possible decision which may have grave results. In such a case, the audi rule applies to the consideration of the preliminary decision. In my view, this is such a case. In other words, what the court is saying here is that usually, or remember when we looked at our legislative analysis, we said that ordinarily the rights or the opportunity for reasonable representations would follow the decision with a view of modifying it. In some instances, it may be required before the decision is taken, or the reasonable opportunity for to make representations, right, would include a pre-decision hearing or before the decision is made. And the court lays the circumstances in which this would be required, stating that where the preliminary decision would lay the necessary foundation for a possible decision which may have grave results. In such a case, the audi rule applies to the consideration of the preliminary decision. And the court noted that this was such a case. It applied, right? So a reasonable opportunity may, in the circumstances, require a reasonable opportunity to make representations in the stage where the decision is still a preliminary decision, not yet a final decision, right? We then now move on to the case of Buffalo City versus Gauze, still on the topic of reasonable opportunity to make representation. The court addressing the issue of whether or not a failure to allow representations prior to a decision being made may be cured later by an opportunity to make representations after said decision was made. In other words, where there's a failing, right, to allow for representations, that failing may be cured by allowing for representations after the decision was made. The court held the failure to invite the landowner, in this case, was in a case in which land included a multi-layered decision-making process. The failure to invite the landlord to make representations before adopting the resolution, that resolution to expropriate his property, violated the principles of fair administrative action, right? The fact that the Premier later planned to allow representations did not cure the defect because the landowner was entitled to a fair hearing before the municipality made its initial decision, right? So we cannot cure the failure of allowing an opportunity to make representations, right? You cannot cure that by allowing for it later or after the decision, right? We then now look at still the same decision, multi-layered decision making, right? And reasonable opportunity to make representations. We look at the case of EarthLife versus Director General, Department of Environmental Affairs and Tourism. Here, the court addressing the question whether an opportunity to make representations ought to be afforded in response to new information, right? New information. In some cases, during the multi-layered decision-making process, new information arises at later stages with more investigations or reports and findings, where a prior opportunity to make representation did not contend with said new information, right? The court addressing this question whether an opportunity to make representations ought to be afforded in response to new information where a prior opportunity to make representations did not contend with that information. That means the previous opportunity to make representation did not involve representations on the kind of information that arose after that process that was new, right? Referring to case law, the court held in the present case where the environmental impact report was substantially overtaken by the draft environmental impact report, which was subject to the prior opportunity by the applicants. Yes, by the applicants where a prior opportunity to make representations, right? So where the draft environmental impact report, which was subject to the prior opportunity to make representation, was substantially overtaken by the final environmental impact report, it is clear to my mind that the new facts had indeed been placed before the decision maker on behalf of ESCOM. In these circumstances, I am of the view that the applicant, as an interested party, was entitled, as part of its rights to procedural fairness, to a reasonable opportunity to make representations. Now, the party is an interested party. Note that the subject of the administrative decision is not an interest by the party. The court is referring to the party as an interested party, right? So the court stated that the interested party was entitled, as part of its rights to procedural fairness, to a reasonable opportunity to make representations to the Director General on the new aspects not previously addressed in its submissions in relation to the draft environmental impact report. Now, it's important for you, because these slides are meant to take you to the heart of the ruling. It's important for you to read the study guide to gain more context on the facts. etc. Right? But here we are getting straight to the point of the ruling of the court, right? So it's important to note that a reasonable opportunity to make representations will arise where in a multi-layered decision-making process where the first opportunity, right, addressed certain issues. A second opportunity would be required where in a later stage new information arises, right? And so an opportunity to make representations to address this new information would be required, right? We then move on to the next case, which is Chairman Board of Tariffs and Trade and Others versus Renco Incorporated, again dealing with the same topic of reasonable opportunity to make representations. The court addressing the question whether an opportunity to make representations at every stage of a decision-making process ought to be afforded where such subsequent decisions were limited in discretion and the first opportunity to make representations proved adequate. Right, so the court now addressing this question where in a multi-layered decision-making process, so we're looking here at multi-layered decision-making process, we found that in the first case, in the first case, we looked at in the prelim decision, an opportunity should be allowed, a reasonable opportunity to make representation would be allowed where it lays the necessary foundation for the final decision, which may have grave results, right? It would apply. We also looked at, again, that it cannot be cured. A failure in this sense cannot be cured if that opportunity would be provided later on after the prelim decision. We then looked now at this case where it spoke about whether they would be allowed in this multi-layered decision-making process to address or to have an opportunity for representations to address that new information. The court held yes, that is the case. And now we look at whether an opportunity to make representations would include an opportunity at every stage, even though the first stage was adequate and the subsequent decisions were limited in discretion, as the case was here, where it was a simple yes or no decision by the subsequent decision makers, right? The court held there was no need for the ministers to give Brenco Incorporated another hearing because Brenco had already had multiple opportunities to present its case during the board's investigation process. The ministers had very limited discretion in terms of legislation. They could only approve or reject the recommendation of the board, right? They were not, in this sense, in terms of their discretion, they were not opening the case anew and investigating it for themselves. They were simply approving or rejecting the recommendation of the board based on the documentation before them. Given that the investigative process was extensive, right, a further hearing would have been unnecessary and redundant, right? So in cases where the subsequent decision makers have a limited discretion of just approving or rejecting the recommendation of the previous decision makers, an opportunity at that stage to make representation would be redundant and unnecessary. That's the finding or the ruling of the court in the Chairman Board on Tariffs and Trade and Others versus Brenco, right? Again, we're looking at now an opportunity to obtain assistance. We're looking at subsection 3A, an opportunity to obtain assistance or legal representation. We look at the case of Hamata and another versus Chairperson, Peninsula Technicon, Internal Disciplinary Committee and others. The court addressing the issue of an entitlement to legal representation as per subsection 3. Remember, we moved now from subsection 2, where we had those 5 requirements, noting that case law is only found for the first 2 Roman numeral requirements, which is adequate notice and reasonable opportunity to make representations. We now look at the discretionary right requirements, and that in particular subsection 3, an opportunity to obtain assistance or legal representation. Looking at the case of Hamata and another, the court addressing the issue of an entitlement to legal representation in administrative proceedings found that PAJA section 3(2)(a) recognizes and reaffirms what had long been axiomatic in common law, namely that a fair administrative procedure depends on the circumstances of each case. Remember that in this particular section, we engage the matter of a fair procedure being an inherently flexible requirement, right? So the court says that Section 3 makes provision for legal representation only in a serious or complex case in which, in order to give effect to the right to procedurally fair administrative action, an administrator decides in the exercise of a discretion to grant an opportunity to obtain legal representation. So the court recognizes this entitlement. The court further found that there may be administrative organs of such a nature that the issues which come before them are always mundane, and the consequences of their decisions for particular individuals also so insignificant that a domestic ruling prohibiting legal representations would neither be unconstitutional nor be required to be read down if its language so permits, to allow for the exercise of a discretion in that regard. In other words, what the court is saying here is that in certain instances, an administrative organ or the administrative decisions that affect the individual are so insignificant, right? And remember, as part of section of the jurisdictional facts, that the administrative decisions consequences must be of a material and adverse effect. The court is also noting that certain decisions are not of this kind. They are insignificant, right? And so it would allow the prohibition of legal representation, right? It would, and that would not be unconstitutional. Okay. However, the court notes, on the other hand, there may be administrative organs which are faced with issues and whose decisions may entail consequences which range from the relatively trivial to the most grave. Any ruling purporting to compel such an organ to refuse legal representation, no matter what the circumstances might be, and even if they are such that a refusal might very well impair the fairness of the administrative proceeding, cannot pass the muster in law, right? So it cannot be that these administrators, right, or administrative bodies, especially in this case, it was a university, right? And it's standard practice for the university to deny legal representations most of the time when there's a disciplinary issue regarding a student. That student would be provided representation by another student or another member of staff. This also involves disciplinary issues relating to staff who may be represented by other staff or the trade union representation. However, they would not be entitled to legal representation, especially where the court is stating these decisions are mundane or inconsequential. However, the court is saying that when the decision is of a serious, right, a serious consequence, right, it's a grave consequence such as expulsion, right, the court is saying that a rule blankets, that's a blanket prohibition, would not pass, right? So saying that legal representation may be required in such circumstances, right? Any rule purporting to compel such an organ to refuse legal representation, this rule referring to the university or technicon's internal disciplinary rules, right? Any rule purporting to compel such an organ to refuse legal representation, no matter what the circumstances might be, and even if they are such that a refusal might very well impair So even in the circumstances where a prohibition might impair the fairness of the administrative proceedings, cannot pass the master-in-law. In other words, if the administrative proceedings demands of fairness that legal representation should be obliged or provided for, given that the result would be grave, right? A blanket ban on legal representation would not pass, right? So, in other words, the court is saying in circumstances where fairness demands or where fairness of the proceedings would be called into question without the providing of legal representation, given that the consequence would be grave, a ban on legal representations or assistance would not pass law, right? It would be set aside, it would be not fair. Okay, we now look at in this part, section 3 of our presentation or our lecture, we look at procedural fairness versus procedural versus substantive legitimate expectations. We are looking at the English cases. And the first case we look at is R versus Secretary of State for the Home Department ex parte Hargreaves, right? In this court, Hers LJ addressing the issue of whether a policy decision created a legitimate expectation that prevents a public authority from later changing its policy found it is common ground that a representation can only be relied upon as the basis for a legitimate expectation if it is clear and unambiguous, finding further that the policy documents did not contain a clear and unambiguous representation and therefore are not a proper foundation for the legitimate expectation for which the applicants contended. You have to note that in this case, Hargreaves is a prisoner, right? And part of the secretary for the Home Department was that prisoners would be able to go home on the weekends for good behavior. And then elections occurred and a new secretary was appointed, and they decided, due to public concerns about this, to change the policy. The applicants contended that this was a legitimate expectations. And we see how Hurst LJ addresses this issue, stating that, remember, the representation can only be relied upon if it is clear and unambiguous, and that the policy documents did not contain a clear and unambiguous representation and therefore are not a proper foundation for the legitimate expectation for which the applicants contended. Now the court, right, Hurst J, in terms of a substantive legitimate expectation held, he rejected the notion of any subjective legitimate expectation and held, given the substance and purpose of the legislative provisions governing parole, the most that a convicted prisoner can legitimately expect is that his case will be examined individually in light of whatever policy the Secretary of State sees fit to adopt, provided always that the adopted policy is a lawful exercise of the discretion conferred upon him by the statutes, right? In other words, the court is saying that the only expectation in this case that the prisoner has is a procedural, right, expectation that his case will be examined, right? That is procedural, right? Any other view, as contended a substantive legitimate expectation, any other view would entail the conclusion that the unfettered discretion conferred by the statute upon the minister can in some cases be restricted so as to hamper or even prevent the changes of policy, bearing in mind the complexity of the issues which the Secretary of State has to consider and the importance of the public interest in the administration of parole, cannot think that Parliament intended the discretion to be restricted in this way, right? Because where a substantive legitimate expectation, if it were to exist, the court is saying that it would hamper the discretion of policy changes by the minister. And so in this case, the court is essentially rejecting the idea of a substantive legitimate expectation as they involve policy decisions, right? We then now move on to the case of RV North and East Devon Health Authority ex parte Cochran, right? In the above case, Lord Wolf, addressing the issue of whether the health authority's promise of a home for life, right? The health authority made this promise that Ms. Cochran would have a home for life and others, right? Created a substantive legitimate expectation that the court would protect if reneged upon. That means you change your mind, you go back on it, you no longer fulfill that promise, right? Considered the nature and or categories and tests requirements of reneging on a legitimate expectation in law and found therein to be announced as follows, right? So what is the court doing here? It considered the nature and categories and or test requirements of reneging on a legitimate expectation in law and found therein to be announced as follows. So what are the requirements to go back on those legitimate expectations, right? So the court held, the court may decide that the public authority is only required to bear in mind its previous policy or other representation giving it weight it thinks right, but no more, before deciding whether to change course, right? Here the court is confined to reviewing the decision on Wednesbury ground, right? This has been held to be the effect of changes of policy in cases involving the early release of prisoners. On the other hand, the court may decide that the promise or practice induces a legitimate expectation of, for example, being consulted before a particular decision is taken. Here it is uncontentious that the court itself will require the opportunity for consultation to be given unless there is an overriding reason to result from it, in which case the court will itself judge the adequacy of the reasons advanced for the change of policy, right? Taking into account what fairness requires. The court then held, where the court considers that a lawful promise or practice has induced a legitimate expectation of a benefit which is substantive, not simply procedural, authority now establishes that here too, the court will in a proper case decide whether to frustrate the expectation, decide whether to frustrate the expectation is so unfair that to take a new and different course will amount to an abuse of power. Here, once the legitimacy of the expectation is established, the court will have the task of weighing the requirements of fairness against an overriding interest relied upon for the change of policy, right? Now, what is here, what's in this case, what is going on, right? So what you must note is the court is in essence here establishing three types of legitimate expectations and, right, what is required in law to break those expectations. So first, it sets about three types of expectations and what would be required for a Department of State or an administrator to resile or renege on that legitimate expectation, right? The court says this. The court may decide that the public authority is only required to bear in mind its previous policy or other representation. This is giving it weight, right? Other representation may be by a prisoner, as the case may be, giving it the weight it thinks right, but no more before deciding whether to change course. Here, the court is confined to reviewing the decision on the Wednesbury grounds. You'll find these grounds dealt with more in depth in your study guide. It's basically reasonableness, right? This has been held to be the effect of changes of policy in cases involving the early release of prisoners. And so what the court is talking here about is known as the policy legitimate expectations, or the legitimate expectations found in policy, right? The court is saying that where the legitimate expectation involves policy, what the public authority is required to do is only bear in mind. So where, right, the legitimate expectation is claimed as part of a policy, and now the public authority wants to change that policy, right, which would affect that legitimate expectation found in policy, the court held that what is required is that the public authority merely bears in mind its previous policy and also the representations made by those who claim it, giving it weight in things right. So it only needs to consider it, and it's upon them, the public authority, to give it the weight it thinks right, but no more, right? No more, no substantive, right? There's no more than it being substantive. So the court in this case, as it regards to policy legitimate expectations, right? The court is saying that what is involved here, right, is simply that the authority bear in mind its previous policy and the representations of those affected, giving it weight in things right, but no more before deciding whether to change course, right? On whether it is reasonable, Wensbury ground, whether it's reasonable, the decision was reasonable, or if it was so unreasonable that no one would take that decision, right? And then on the second one, the court held that on the other hand, the court may decide that the promise of practice, here it's policy, right? It's not a promise of practice. These are policy legitimate expectations. Here, B, on the other hand, the court may decide that the promise of practice induces a legitimate expectation of, for example, being consulted before a particular decision is taken. This now the court is essentially talking about a procedural legitimate expectation, a legitimate expectation to be consulted before a decision is taken, right? The promise to be consulted, where that promise is made, or a practice, a regular practice where persons were consulted before decisions were taken, saying that this may induce a legitimate expectation of, for example, being consulted before a particular decision is taken, right? The court is talking about a procedural legitimate expectation that would involve consultation before the decision is taken. Here, it is uncontentious that the court itself will require, the opportunity for consultation to be given unless an overriding reason to resile from it, in which case the court will itself judge the adequacy of the reasons advanced for the change of policy, right? Taking into account what fairness required, right? When it talks about policy, it talks about the administrative policy or regular practice, right? But it's not involving a policy legitimate expectation, but a procedural one. So where a procedural legitimate expectation is given rise to, what is required is an opportunity for consultation, and should now, right, remember the court is talking about the circumstances under which they can go against it or not follow it, says that they must have overriding reasons to resile from that procedural legitimate expectation or that promise or regular practice, in which case the court is saying that where they do that, where they do resile from it or move away from following that regular practice or not giving effect to that promise that gave rise to a procedural legitimate expectation, the court will judge the adequacy of the reasons advanced for not doing that, taking into account what fairness requires, right? And in C, now the court addresses or brings about this new idea of a substantive legitimate expectation. A substantive legitimate expectation. Here the court held that when the court considers that a lawful promise or practice has induced a legitimate expectation of a benefit, right? Not of a fair procedure, but of a benefit which is substantive, like the promise of a house, which is a benefit and not a procedure, which is substantive, not simply procedural. Authority now establishes that here too the court will in a proper case decide whether to frustrate the expectation, so that means to go against, to renege on that substantive benefit or that legitimate expectation that arises from that substantive or of that substantive benefit is so unfair that to take a new and different course will amount to an abuse of power. It is so unfair, all right, that it would amount to an abuse of power. The court held that here, once the legitimate expectation is established, that of a substantive benefit, the court will have the task of weighing the requirements of fairness against an overriding interest relied upon for the change of policy. Then, in other words, simply the change of the decision to frustrate or deny the substantive benefit. If the court finds, right, that the requirements of fairness, right, outweigh an overriding interest, whether the court states that that interest is perhaps maybe public financing. If the court finds that fairness outweighs perhaps that interest, then the court will give effect to that substantive legitimate expectations. It is important for you to read the study guide, right? And so that you can read this English case more comprehensively and see how the court deals with this interesting matter, right? Now we go to our last case, which is Abdi and Nandaraja versus Secretary of State for Home Department, Laws LJ, addressing the issue of legitimate expectations, resolves the confusion that surrounds the previous two cases, right? Because the first case says only procedural. The second case of Cochran now invites the idea of a substantive legitimate expectation. Also procedural is confirmed and policy as well, right? Albert Orbiter, providing the search for principle surely starts with the theme that is current through the legitimate expectation cases. It may be expressed thus: where a public authority has issued a promise or adopted a practice which represents how it proposes to act in a given area, the law will require the promise or practice to be honored unless there is good reason. Remember, even Cochran talked about reasons, good reasons not to do so. What is the principle behind this proposition? It is said to be grounded in fairness, and no doubt, in general terms, that is so. However, this is what Lord J says. I would prefer to express it rather more broadly as a requirement of good administration by which public bodies ought to deal straightforwardly and consistently with the public. That being so, there is every reason to articulate the limits of this requirement, to describe what may count as good reasons to depart from it. So here, right, in this case, the court is addressing the reasons, what would count as good reasons to depart from a legitimate expectation, regardless of whether that legitimate expectation then is substantive, procedural, or a policy. Legitimate expectation, the court held. Accordingly, a public body's promise or practice as to future conduct may only be denied, and thus the standard I have expressed may only be departed from in circumstances where to do so is the public body's legal duty, or is otherwise, to use a now familiar vocabulary, a proportionate response, of which the court is the judge or the last judge having regard to a legitimate aim pursued by the public body in the public interest. Remember, even in Cochrane, they talked about an overriding public interest, overriding interest. Here, the court is talking about that interest being an overriding public interest. So if the overriding public interest outweighs the fairness, right? The fairness of denying the legitimate expectation, then denying that legitimate expectation would stand. However, if it does not, if the legitimate aim or the legitimate aim that is pursued in the public interest, which is to deny the legitimate expectation of the particular person, does not outweigh, right? In terms of fairness, does not outweigh that denying, then it would not stand, right? So the principle that good administration requires public authorities to be held to their promises would be undermined if the law did not insist that any failure or refusal to comply is objectively as justified as a proportionate measure in the circumstances, right? The court is saying here simply that where a public authority decides to depart from a legitimate expectation, whether it be substantive, procedural, or policy, then it must provide an overriding public interest for doing so. In other words, that public interest should outweigh the unfairness that would be brought about denying that legitimate expectation. It must outweigh, right, in regards to that legitimate fairness. In other words, fairness would allow for that legitimate expectation to be denied if the public interest overrides it. And that's the only circumstance in which they can deny a legitimate expectation, as the category may be. Okay, so guys, we've come to the end of this lecture, Procedural Fairness Section 3. I hope that it has been informative for you and that you now understand this topic. And I hope that it's quite a challenging topic, but hopefully that with you listening to this lecture, it has become more clear. And if you have, the study guide, that would be helpful as well. And you should be good to go in terms of this topic, right? From me, good luck and goodbye.